So continuing with our discussion, we're talking about the criminality of HIV transmission. Um, so there are laws expressively to criminalize HIV transmission or exposure, charging those accused with criminal transmission of HIV, which is a misdemeanor. In the United Kingdom, like I said before, there are specific laws that they charge people who transmit HIV to other people willingly or unwillingly or unknowingly with murder, manslaughter, attempted murder, or assault. In many English-speaking countries and in the European Convention of Human Rights, knowingly infecting others with HIV can lead to criminal prosecution. In 2004, a survey of the latter group of global network of people living with HIV/AIDS found that at least one prosecution had occurred in about half of these countries, and that in Finland, Slovakia, about 0.5% to 1% of all people reported to be living with HIV and AIDS have been prosecuted for alleged intentional or negligent transmission of HIV. Now, we spoke earlier about China. In Thailand, where the HIV/AIDS pandemic has been much more serious, laws regarding criminalization of intentional transmission have either been weak or non-existent. So from a global perspective, the US and Canada account for the vast majority of reported prosecutions. So they were not able to find in courts in the European Union a way to initially charge someone, prosecute someone with, and give them time or a sentence or a fine successfully for intentionally infecting someone with HIV, which is also the issue that they're having in the United States, which is why the Supreme Court has overturned the issue. Because the Supreme Court doesn't necessarily find that people who may or may not know of their status, infecting another person knowingly or unknowingly is not actually killing the person, sentencing the person to death, assaulting the person, or intentionally infecting this person, which means they can't prosecute for it, which is a dilemma that they're having in the United States, which is why states have been trying to get a clear-cut bill that can discern whether or not a person is capable of intentionally giving someone HIV. And that's the issue that we have now. In continuation, they tried in the Crimes Act of 1900, and this is in Europe, not in the United States, they said that this was a grievous damage of bodily harm. So they're saying that infliction of HIV on someone is a grievous bodily harm. So when you initially have sexual contact with someone in Europe, you're infecting them with a grievous bodily harm injury. And because of that, the person is committing a crime. Now, technically, HIV, which is a virus, like hepatitis B and C and A, are not grievous bodily harms. There's no different. It's similar to whether or not you can prosecute someone for giving you a cold or giving you the flu. Typically at employment agencies or corporations, when a person is sick, the employer does not want the person to come to work sick, because then they'll give their cold or flu to everyone else who's at work, and then there'll be more people at sick leave or on sick leave for a cold versus one person who has a cold. So it's similar to that in that aspect, that a person who is giving someone, intentionally giving someone a cold, is intentionally giving someone HIV. Secondly, HIV is not terminal. So when you think of charging someone with manslaughter, murder, or assault, you think of someone that is intentionally hurting this person, manslaughter specifically, whether it's premeditated or non-premeditated, and that this person has now a victim because of an act that this one person, the perp, has inflicted on this person. Most sexual interactions don't involve a force. If there's a rape allegation, that could make some causality in whether or not the person is inflicting bodily harm on them. But then pregnancy comes into account as well. If a man impregnates a female and transmits HIV to her, he has inflicted bodily harm on her and he has impregnated her, and now she is stuck with a baby and she's also stuck with a disease. This isn't terminal for her though, which is why it's not criminal, because the act of rape is criminal, but just the fact that the person has impregnated you and as well infected you with a disease is not terminal, because you're able to live 20, 15, 10 years with HIV in this country with modern medicine. So because of that, it's very difficult for any court system to prosecute. I want to speak specifically about some representatives who returning to the grievous bodily harm. This means that infliction of grievous bodily harm refers to causing a person to contract a grievous bodily disease. So specifically they're speaking of bodily harm in terms of a disease. And in Europe, they can be imprisoned for up to 25 years, while under Section 35, a person who recklessly causes another person grievous bodily harm can be imprisoned for up to 10 years and 14 years if in company. This can include causing someone to be infected with HIV. A person is generally deemed as reckless when they are aware that there is a risk that another person may be caused grievous bodily harm as a result of their actions, but they proceed to act anyway. So then that is very different. Now, if you can prove that this person has inflicted grave bodily harm on you by engaging in a sexual encounter with you, whether by force or by choice, and has not disclosed their status to you, whether or not they're infected with any diseases or not, then they could assume that they have created grave bodily harm to you. Now, the stipulations for the United States. 30 states have prosecuted HIV-positive individuals for exposing another person to HIV. A person diagnosed with HIV who infects their partner while engaging in sexual intercourse is committing a crime. A person donating HIV-infected organs, tissues, and blood can be prosecuted for transmission of the virus as well. Spitting or transmitting HIV-infected bodily fluids is also considered a criminal offense in most states, particularly where the target is a prison guard. Some states consider criminal transmission of HIV a misdemeanor. Now, in July 2010, the White House announced a major change in its HIV/AIDS policy, a change informed by public health law research carried out by Scott Burris, a professor of law at Temple University and the director of public health law research program. The Obama administration's national HIV/AIDS strategy for the U.S. concluded that, quote, the continued existence and enforcement of these types of laws that criminalize HIV infection run counter to scientific evidence about the roots of HIV transmission and may